De Castro vs. Assidao de Castro, Gr. Number 160172, February 13, 2006. Facts: Petitioner and respondent met and became sweethearts in 1991. They planned to get married, thus they applied for a marriage license with the Office of the Civil Registrar of Pasig City in September 1994. They had their first sexual relation sometime in October 1994, and had regularly engaged in sex thereafter. When the couple went back to the Office of the Civil Registrar, the marriage license had already expired. Thus, in order to push through with the plan, in lieu of a marriage license, they executed an affidavit dated March 13, 1995 stating that they had been living together as husband and wife for at least 5 years. The couple got married on the same date, with Judge Jose C. Bernab, presiding judge of the Metropolitan Trial Court of Pasig City, administering the civil rights. Nevertheless, after the ceremony, petitioner and respondent went back to their respective homes and did not live together as husband and wife. On November 13, 1995, respondent gave birth to a child named Reinna Tricia A de Castro. Since the child's birth, respondent has been the one supporting her out of her income as a government dentist and from her private practice. On June 4, 1998, respondent filed a complaint for support against petitioner before the Regional Trial Court of Pasig City Trial Court. In her complaint, respondent alleged that she is married to petitioner and that the latter has reneged on his responsibility, obligation to financially support her as his wife and Reinna Tricia as his child. Petitioner denied that he is married to respondent, claiming that their marriage is void ab initio since the marriage was facilitated by a fake affidavit and that he was merely prevailed upon by respondent to sign the marriage contract to save her from embarrassment and possible administrative prosecution due to her pregnant state and that he was not able to get parental advice from his parents before he got married. He also averred that they never lived together as husband and wife and that he has never seen nor acknowledged the child. The trial court ruled that the marriage between petitioner and respondent is not valid because it was solemnized without a marriage license. However, it declared petitioner as the natural father of the child, and thus obliged to give her support. The Court of Appeals denied the appeal of petitioner. Court of Appeals frowned upon petitioner's refusal to undergo DNA testing to prove the paternity and filiation, as well as his refusal to state with certainty the last time he had carnal knowledge with respondent, saying that petitioner's forgetfulness should not be used as a vehicle to relieve him of his obligation and reward him of his being irresponsible. Petitioner contends that the trial court properly annulled his marriage with respondent because, as shown by the evidence and admissions of the parties, the marriage was celebrated without a marriage license. He stresses that the affidavit they executed, in lieu of a marriage license, contained a false narration of facts, the truth being that he and respondent never lived together as husband and wife. The false affidavit should never be allowed or admitted as a substitute to fill the absence of a marriage license. Issue: whether the trial court had the jurisdiction to determine the validity of the marriage between petitioner and respondent in an action for support. Held: yes, the court holds that the trial court had jurisdiction to determine the validity of the marriage between petitioner and respondent. The validity of a void marriage may be collaterally attacked. Thus, in initio vs. by a dog, SC held, however, other than for purposes of remarriage, no judicial action is necessary to declare a marriage an absolute nullity. For other purposes, such as but not limited to determination of heirship, legitimacy or illegitimacy of a child, settlement of estate, dissolution of property regime, or a criminal case for that matter, the court may pass upon the validity of marriage even in a suit not directly instituted to question the same so long as it is essential to the determination of the case. This is without prejudice to any issue that may arise in the case. When such need arises, a final judgment of declaration of nullity is necessary even if the purpose is other than to remarry. The clause on the basis of a final judgment declaring such previous marriage void in Article 40 of the Family Code connotes that such final judgment need not be obtained only for purpose of remarriage. Likewise, in Nightdale Carreño vs. Ye Carreño, the court ruled that it is clothed with sufficient authority to pass upon the validity of two marriages despite the main case being a claim for death benefits. Reiterating Neinio, we held that the court may pass upon the validity of a marriage even in a suit not directly instituted to question the validity of said marriage, so long as it is essential to the determination of the case. However, evidence must be adduced, testimonial or documentary, to prove the existence of grounds rendering such a marriage an absolute nullity. Under the Family Code, the absence of any of the essential or formal requisites shall render the marriage void ab initio, whereas a defect in any of the essential requisites shall render the marriage voidable. In the instant case, it is clear from the evidence presented that petitioner and respondent did not have a marriage license when they contracted their marriage. Instead, they presented an affidavit stating that they had been living together for more than 5 years. However, respondent herself in effect admitted the falsity of the affidavit. The falsity of the affidavit cannot be considered as a mere irregularity in the formal requisites of marriage. The law dispenses with the marriage license requirement for a man and a woman who have lived together and exclusively with each other as husband and wife for a continuous and unbroken period of at least 5 years before the marriage. The aim of this provision is to avoid exposing the parties to humiliation, shame and embarrassment concomitant with the scandalous cohabitation of persons outside a valid marriage due to the publication of every applicant's name for a marriage license. In the instant case, there was no scandalous cohabitation to protect. In fact, there was no cohabitation at all. The false affidavit which petitioner and respondent executed so they could push through with the marriage has no value whatsoever. It is a mere scrap of paper. They were not exempt from the marriage license requirement. Their failure to obtain and present a marriage license renders their marriage void ab initio. Issue 2. Whether the child is the legitimate daughter of petitioner. Held, no, SC held that the child is petitioner's illegitimate daughter, and therefore entitled to support. Illegitimate children may establish their illegitimate filiation in the same way and on the same evidence as legitimate children. Thus, one can prove illegitimate filiation through the record of birth appearing in the civil register or final judgment, an admission of legitimate filiation in a public document or a private handwritten instrument and signed by the parent concerned, or the open and continuous possession of the status of a legitimate child, or any other means allowed by the rules of court and special laws. The certificate of live birth of the child lists petitioner as the father. In addition, petitioner, in an affidavit waiving additional tax exemption in favor of respondent, admitted that he is the father of the child. SC are likewise inclined to agree with the following findings of the trial court, that Reinna Tricia is the child of the respondent with the petitioner is supported not only by the testimony of the latter, but also by respondent's own admission in the course of his testimony wherein he conceded that petitioner was his former girlfriend. While they were sweethearts, he used to visit petitioner at the latter's house or clinic. At times, they would go to a motel to have sex. As a result of their sexual dalliances, petitioner became pregnant, which ultimately led to their marriage, though invalid, as earlier ruled. While respondent claims that he was merely forced to undergo the marriage ceremony, the pictures taken of the occasion reveal otherwise.